We are witnessing an unprecedented and profoundly dangerous shift in the legal landscape surrounding your Second Amendment rights. The stakes have never been higher, impacting every single firearms owner across the nation. What began as a ripple in the Supreme Court is now a tidal wave of legal challenges, regulatory overreach, and personal liability that threatens to entrap the uninformed. You must understand these changes, or you risk facing severe legal consequences, including felony charges, financial ruin, and the permanent loss of your fundamental rights. The era of casual ownership is over. We are now in a high-stakes legal battleground. The catalyst for this seismic shift did not originate in the halls of Congress or within the federal bureaucracy. Instead, it stemmed from the determined actions of two ordinary citizens, Robert Nash and Brandon Coe. These men sought nothing more than the basic right to self-defense, a right many others already exercised without impediment. They meticulously adhered to every state requirement, undergoing training, passing stringent background checks, and maintaining impeccable records. Yet, when they sought concealed carry permits, they were met with a familiar, entrenched denial. They were informed, in essence, that they were not sufficiently special to qualify for a right that should be inherent. This denial was not an anomaly. It was the standard operating procedure, a century-old institutional practice. For over 100 years, a select group of unelected officials wielded immense power, arbitrarily deciding who faced enough personal danger to warrant protection, and by extension, who did not. They determined who counted as a responsible citizen capable of carrying a firearm, and who would remain disarmed and vulnerable. This discretionary, subjective system stood as a formidable gatekeeper, effectively shrinking a constitutional right into a mere privilege granted at the whim of the state. Nash and Co. refused to accept a system built on such arbitrary guesswork and personal opinion. Their challenge was not a minor dispute. It meticulously exposed the deep-seated weaknesses and constitutional infirmities within a legal structure that had largely escaped rigorous scrutiny for far too long. Their case, ultimately known as New York State Rifle and Pistol Association versus Bruen, escalated beyond anyone's initial expectations, reaching the highest court in the land. The resulting 6-3 decision by the Supreme Court did not merely adjust a policy. It fundamentally rewrote the rules for the entire nation, ending a century of unconstitutional gatekeeping. When the Supreme Court finally released its landmark ruling, it did not do so with subtlety or a slow build. It struck with the force of a legal earthquake, hitting all at once. In a decisive 6-3 split, the justices delivered an unequivocal message. The Second Amendment is not a malleable concept that government entities can expand, contract, or treat as a privilege to be earned or denied based on subjective criteria. Justice Clarence, writing for the majority, emphatically shut the door on the long-standing practice that allowed states to weigh constitutional rights against shifting public anxieties or transient political pressures. For decades, lower federal courts had widely embraced a judicial approach known as the two-step framework, or means-end scrutiny. This framework often allowed courts to uphold almost any gun control restriction put before them, provided the state could articulate some rational public safety concern. Under this regime, ordinary citizens possessed virtually no effective mechanism to challenge these restrictions successfully. The Bruen ruling, however, instantly and definitively closed that chapter of judicial deference to state legislative discretion. The court declared that if a government now seeks to block a citizen from carrying a firearm, it bears the heavy burden of demonstrating that the challenged regulation has a clear and unambiguous historical pedigree. Specifically, the government must prove that the rule is consistent with the nation's historical tradition of firearm regulation, particularly from the founding era. No longer could states rely on vague, broad claims of public safety, no more just-in-case arguments rooted in modern social science data or statistical projections. Crucially, the burden shifted dramatically. Citizens were no longer required to justify why they deserved constitutional protection. Instead, the government must now justify why it seeks to infringe upon that protection. Everything fundamentally flipped in that singular, decisive moment. States that had previously denied permits without hesitation, operating under their discretionary may-issue regimes, suddenly found themselves held to a dramatically stricter standard. This was not a minor adjustment to administrative procedure. It was a wholesale rewriting of the legal framework governing firearms carry, transforming may-issue into a de facto shall-issue mandate, predicated upon objective, historically sound criteria. Here is where everything took a sharp, unforeseen turn, a shift whose profound implications most people still do not fully grasp. Once the Bruen ruling was issued, the Supreme Court made it unequivocally clear that lower court judges could no longer rely on modern justifications to uphold gun control laws. This meant no more reliance on contemporary crime statistics, no more sociological surveys, and no more emotionally charged claims about generalized public concern. Instead, every existing and future restriction on firearms carry must now survive one straightforward, indeed unforgiving, constitutional question. Did Americans face a similar rule, rooted in clear historical precedent, when the Second Amendment was ratified in the late 1700s? If the answer to that foundational historical question is definitively no, then the law stands on exceedingly shaky constitutional ground from its very inception. This is precisely where many states are now stumbling, caught in a legal quagmire. They rush into court with voluminous explanations and passionate arguments about contemporary public safety needs, only to be unequivocally informed that none of it matters unless they can point to a direct, analogous historical regulation from the founding era that precisely matches the modern restriction they are attempting to enforce. Federal judges in jurisdictions across the nation, including highly restrictive states like California and Illinois, have already begun to invalidate major gun control restrictions because the respective states have utterly failed to demonstrate any credible historical example of such limits existing during the relevant period. This new historical test did not merely raise the evidentiary bar. It entirely reconfigured the litigation process itself. Instead of citizens fighting an uphill battle against presumptively valid state laws, it is now the states that are scrambling, often desperately, to justify rules they once defended without question or historical basis. And as predicted, many of those deeply entrenched rules simply cannot survive the rigorous application of this new, historically focused, constitutional standard. The immediate aftermath of the Bruen ruling triggered a permit surge that state officials never anticipated, nor were they prepared to handle. The doors they had kept virtually closed for generations, effectively suppressing constitutional rights, were suddenly thrown wide open. The ensuing rush for permits hit harder and faster than anything their bureaucratic agencies had ever prepared to manage, exposing severe systemic vulnerabilities. Consider the dramatic example of Hawaii. For years, fewer than 200 private citizens held active concealed carry permits across the entire state. As soon as the old subjective good cause rules were struck down, those numbers exploded. Within mere months, thousands of ordinary residents stepped forward, reactivating applications that had languished in silence for decades, knowing full well the answer would always be a predetermined no under the old regime. Los Angeles County, a sprawling metropolitan area home to millions, felt the shock of this paradigm shift even more acutely. A region that previously had only a few hundred active permits found itself suffocated under the weight of thousands of new filings in just half a year. Licensing offices were forced to remain open late into the night. Clerks worked through mountainous piles of applications that grew faster than they could possibly shrink them. Counties were compelled to allocate emergency funding and add significant staff just to prevent the entire permitting system from collapsing under its own unprecedented weight. New Jersey experienced a similar, staggering surge, jumping from a small, yearly trickle of applications to tens of thousands of requests. The state's entire permitting process, built for an era of systemic denial, demonstrably slowed under the crushing pressure. Officials openly admitted they had never conceived of a future where regular citizens would finally stand on equal constitutional ground, demanding their rights en masse. What began as a pivotal court decision rapidly transformed into a real-time, nationwide wave of applications that continues to move through December and is projected to push even harder as we head towards the critical period of 2026. Now, here is the part that has blindsided a significant number of observers and firearms owners alike. While the Bruen ruling decisively opened the door to constitutional carry, some states immediately began erecting new, insidious obstacles directly in front of it. They did not achieve this through overt, outright bans or bold legislative announcements. Instead, they weaponized bureaucracy, deploying an array of complex paperwork, arcane technicalities, and seemingly harmless rules that, upon closer inspection, tighten restrictively the moment a citizen attempts to navigate them. California, a state notoriously resistant to Second Amendment rights, moved swiftly. Lawmakers rolled out an entirely new set of sensitive place location rules that transformed ordinary towns and cities into complex patchwork zones where lawful carrying became a high-risk guessing game, fraught with the potential for inadvertent felony charges. Parks, public transit systems, entertainment venues, buildings tangentially tied to government activity, and even specific stretches of city blocks suddenly became legal minefields. A lawful carrier could, without any malicious intent, stumble into serious legal trouble by unknowingly entering one of these newly designated sensitive places. This was not announced as a broad prohibition, but anyone scrutinizing the legislation closely could easily discern its true intent: to create a de facto ban through geographic complexity and the threat of severe penalties for honest mistakes. New York State, another bastion of restrictive gun control, followed with its own distinct twist, pushing the boundaries of constitutional interpretation. Applicants for concealed carry permits were suddenly mandated to surrender years of their social media accounts for official review. This requirement allowed state officials to sift through an individual's private posts, assess their tone, analyze their opinions, and scrutinize their speech, all to subjectively determine whether these elements made them a concern in the eyes of the state. This represents an unprecedented infringement on First Amendment rights as a precondition for exercising a Second Amendment right. Furthermore, most private property became automatically off-limits for carrying firearms unless owners explicitly posted signs permitting carry, signs that predictably almost no business or private entity chooses to display, thus creating vast default gun-free zones. This was not open, direct resistance to Bruen. It was quiet, procedural pushback, artfully disguised within bureaucratic requirements. It effectively moved the constitutional fight from the rarefied atmosphere of the courthouse directly into the daily lives of law-abiding citizens. Behind every firearms permit and every licensing decision, there exists a vast, multi-million-dollar system. This intricate network comprises certified training centers, approved instructors, specialized fingerprinting offices, and layers of dedicated licensing staff. This entire ecosystem grew and thrived around the strict, often arbitrary rules that states enforced for decades. While rarely discussed in public discourse, this system generated enormous revenue through mandatory classes, recurring renewal fees, and extensive lists of required, often expensive, procedural steps. When the Bruen ruling struck, that entire financially robust setup began to wobble precariously, because many of those long-standing requirements now face the identical historical test that brought down the older, discretionary permit rules. In states like California, individuals routinely paid hundreds of dollars for lengthy, often repetitive training sessions, merely to be eligible to apply for a permit. Maryland collected millions of dollars each year through similar mandatory demands. However, courts are now rigorously questioning whether these exorbitant costs and burdensome steps effectively shut out responsible citizens who simply do not possess the disposable income to spare. More fundamentally, courts are asking whether such significant financial barriers ever existed or were constitutionally permissible when the Second Amendment was originally written. If judges ultimately decide that these costs and procedural hurdles cross a constitutional line by creating an undue burden or lacking historical precedent, the entire infrastructure that has managed this business for years could contract rapidly and dramatically. As these challenges relentlessly advance through December and into 2026, the immense pressure on that billion-dollar system is only intensifying, foreshadowing potential insolvency for many of its components. Here is where the narrative shifts from immediate reaction to an overwhelming tide of legal opportunity. The courtroom battle did not conclude with the 6-3 Bruen ruling. It multiplied exponentially. Once the new text, history, and tradition standard firmly took hold, legal advocacy teams and constitutional lawyers across the country immediately commenced challenging nearly every gun control rule that could not credibly align with early American historical practice. And instead of a slow, intermittent trickle of cases, it rapidly transformed into a veritable flood. Currently, more than 300 active lawsuits are moving through the federal courts, each one posing a deceptively simple yet profoundly powerful question that was largely disallowed under the previous legal regimes. Does this specific gun control rule actually match anything from the founding era, or indeed, any period in the nation's consistent historical tradition of firearm regulation? Some of these crucial challenges focus on age limits that currently block law-abiding adults under the age of 21 from purchasing handguns, even though historical records unequivocally demonstrate that young men in this country carried and owned their own weapons as an integral part of civic life during the nation's formation. Other lawsuits target lifetime firearms bans imposed on individuals who made nonviolent mistakes or committed minor infractions decades ago, profoundly questioning why a single, old, non-violent offense should permanently erase a fundamental constitutional right forever. Cases in several pivotal states are also vigorously pushing back against protracted waiting periods, arbitrary restrictions on commonly owned rifles that millions of Americans already possess, and severe limitations on magazine capacity, arguing with increasing success that none of these rules possess any credible early historical support. What makes this current moment uniquely different is the palpable sense of momentum that now favors individual rights. There is a very real and indeed growing possibility that multiple long-standing, deeply entrenched firearms restrictions could fall en masse as federal judges apply the new historical test with increasing confidence and precision. With many of these foundational cases expected to reach the highest appellate courts through 2026, firearms owners are not just witnessing the collapse of old, unconstitutional barriers. They are witnessing the profound chance for a fairer, constitutionally compliant system to grow stronger with every single ruling. For every regular firearms owner, this is not some distant, abstract legal story playing out on academic paper. This is a dynamic, evolving legal landscape that directly changes how you live your life, how you move through your day, and how you exercise your constitutional rights. A process that once felt agonizingly slow, deliberately confusing, and fundamentally stacked against you is now, demonstrably, shifting in your favor. Many states can no longer lean on the old, unconstitutional excuses they have deployed for years. If you meet the objective, basic legal requirements, you finally possess a clear and constitutionally protected path to obtaining a permit, without being forced to prove you live under special danger, or facing endless, arbitrary delays that never made rational or legal sense in the first place. However, there is another, equally critical side to this transformative moment, and it is imperative to keep it front of mind. States that have lost their old, unconstitutional authority are now actively attempting to construct new, equally problematic restrictions in different corners of the legal map, often cloaked in bureaucratic complexity or novel interpretations of the sensitive places doctrine. This means that you, as a responsible firearms owner, absolutely need to know which places are now arbitrarily designated as off-limits, how local rules are subtly changing, and what new court decisions might further adjust or challenge those legal boundaries. As we relentlessly move through 2026, the legal landscape is shifting with unprecedented speed and unpredictability. Staying fully informed, staying legally current, and understanding the nuances of these rapid changes is no longer merely an option. It is now an indispensable part of responsible, lawful firearms ownership. And there it is. One monumental Supreme Court ruling that didn't just alter a single law, it irrevocably changed the entire direction of the constitutional conversation surrounding your Second Amendment rights. As states continue to adjust their legal strategies from December forward, and as more of these foundational cases advance toward 2026, this critical fight is far from settled. If you want to stay ahead of every single legal shift, every new regulation, and every crucial court decision that will directly impact your rights and your personal liberty, then you must subscribe to our analysis now. Drop your urgent thoughts in the comments below and tell us which part of this ruling or the subsequent state reactions surprised you most. Stay alert, stay meticulously informed, and I will ensure you are equipped with the knowledge you need in the next critical update.